Hello everybody. Thank you very much indeed for sparing the time to log into this webinar, which is about the proposed Solicitors Qualifying Exam. My name is Julie Brannan and I am Director of Education and Training at the SRA. What we will do over the course of the webinar is talk through these slides. There will be an opportunity for you to register to raise questions. So please, if you do have any comments, observations, queries, please do type them into the system and we will pick up those questions as we're going through. I've also got some questions that I'd like to throw out to you to get your views on it as we're working through. So we'll try to make this as dynamic and interactive as possible. So, starting off, the SQE journey, how have we got to where we are now? The start of everything really was the Legal Education and Training Review Report, the little yellow flag at the top left-hand corner of your screen, which talked to us and told us that what we needed to do is to have a regulatory system for legal education which was more flexible and gave us a higher level of assurance of end standards. On the back of that, we launched Training Tomorrow and our policy statement. And the first stage of our work was to develop the Solicitor's Competence Statement, which was published in April 2015. We had a lot of engagement around that. You can see from the slide that we had an online survey, and on that we had over 1,000 respondents. We also spoke to about 500 consumers. We held interviews and workshops. So a lot of engagement and participation went into the development of the competence statement. And then having, if you like, articulated the competencies that we said all solicitors should have, we then started to look at how we might assess those competencies. And we started thinking about options around that. We thought about whether we could include that assessment within the existing statement, the existing structure, and we also thought about whether we could have a standalone assessment, and we started testing in due course the Solicitors Qualifying Exam. So we undertook a lot of engagement around that. We spoke to employers, solicitors, universities. Along the line, we approved the solicitor apprenticeship, and in December last year, we launched our first SQE consultation. Again, that prompted an awful lot of engagement. We had a high number of responses to the consultation. And we had requests for lots more information. So people wanted to know not just more detail about what the assessment might look like, but also how it fitted into the wider system for regulation of legal education. And therefore, we said we would publish a second consultation which answered and addressed some of the questions that stakeholders had. And that's taken us to the current consultation that we published on the 3rd of October. Why is it that we say we need the SQE? And again, this goes back to the core points that the Legal Education Training Review raised: to assure high standards, but be more flexible in our requirements for training and work experience. So we believe that the core benefits that come from the SQE are that we can assure all intending solicitors in a consistent, fair and rigorous way. We think that this will underpin the standing of the solicitor's profession in this country and abroad. We think it does enable us to be more flexible about our requirements, as I said a moment ago, not just for work experience, but around the particular training courses and pathways to qualification that people follow. And we also think that there are cost benefits. We think in particular it addresses the concern which we know people have around the current system, which not only requires people to pay for expensive training in the form of the LPC on top of a degree, but it also requires a large number of students to register for the LPC before they know whether they are going to be able to get a training contract. So we think it addresses a number of those issues. And I'd be interested really in your views about whether you think that these are the right sort of things we should be looking for from our current proposals. Any observations or comments from you at your end?
Hi everyone, I'm Liz Walters. I'm a policy associate working with Julie, and I'm going to be reading out the questions that you post during this webinar. One of the questions we've received already is about our international benchmarking, and someone's asked if Julie could say a little bit more about the international benchmarking and how that helped us in developing the SQE.
Yes, so in terms of international benchmarking, we looked at a range of different jurisdictions across the world. We looked at some of the largest jurisdictions. We looked at some of the jurisdictions which are most obviously competitor jurisdictions to England and Wales. And we also looked at jurisdictions which were both common law and civil law jurisdictions. And what that showed us is that actually the idea of a centralised bar test is very, very widespread. That is the norm, if you like, in terms of how people are admitted to professions, legal professionals throughout the world. So our proposals really are mainstream in terms of international benchmarking. We have talked to international regulators, we've shared our proposals with them, and we've had positive reactions. We've also had the sort of reactions which say, well, this is what we would expect you to be doing. So from the international point of view, this is, as I said a moment ago, a mainstream proposal. So we know from the first consultation that some solicitors were concerned about how this would affect the standing of the solicitor profession internationally. I think one of the comforts we take from our international benchmarking is that this should, we hope, uphold the international standing of the profession. And we also take comfort from the ComRes research that we did, the poll that we did in terms of looking at the domestic impact, where 3/4 of those polled who were domestic consumers of legal services said they would have more confidence in the profession if everybody passed the same exam. So we think this can promote and uphold the reputation of the profession both internationally and domestically. So I'll move on to the next slide, which begins to get us into the detail of what it is we are proposing. I hope you can see now the slide that says 4 elements for qualification. And this is a development of what we said in our first consultation. What we are clear about is that the SQE stages 1 and 2 is a part of our requirements for qualification. And as you can see from the slide, there would be 4 limbs, 4 requirements that intending solicitors would have to satisfy by the time they reach point of qualification. So by the time they were admitted as a solicitor, candidates would have to show to us that they had a degree or equivalent qualification. And I'd like to spend a little bit of time on this because there has been some press comment around this and some misunderstanding, I think, in the press. We picked up quite a strong set of views from the first consultation that many respondents wished to see the profession continue to be a mainly degree or mainly graduate qualification. What I should say on that is that we picked up little appetite for the profession to be an exclusively graduate profession. Many respondents recognised the contribution that solicitors have made over the years who qualified through the SILEX route, and also the historical context in which many solicitors for many years qualified through 5-year articles instead of a 2-year training contract. And few people, as I say, told us that they wanted all solicitors without exception to have a degree. And so our proposal for a degree or equivalent is really where we are at the moment. At the moment, most solicitors have a degree, but we also recognise other alternatives in terms of routes to qualification. But we are clearer now in our second consultation that we would require candidates to have a degree or, as I say, an equivalent qualification. We would also require intending solicitors to pass stages 1 and 2 of the Solicitors Qualifying Exam, which I will come on to describe in a bit more detail in a moment. We would expect them to have a substantial period of work experience, and once again, I would expect them to, I will come on to explain that in a bit more detail in a moment, and we would expect them to meet our character and suitability requirements. So those will be the 4 elements which would have to be fitted together, the 4 pieces of the jigsaw, by the time people reach qualification. Have you had any questions at that point, Liz?
Yeah, we've had a question about what will happen with QLDs in this model, so what will happen to qualifying law degrees, and also a question about whether we'll continue to monitor the quality of law degrees if the SQE is introduced.
Those are a couple of points which we'll pick up later on, but just to deal with them at a high level now, we would. Our proposal would be to regulate training through, if you like, releasing information about performance by different groups of providers on SQE stages 1 and 2. What we want to move away from is the current tripartite structure of training, where we have the academic stage of training, then the professional stage, then the workplace. And I'll explain in a moment how we would wish to work away from that. We think that that has led to silos where actually the real competencies needed for practice as a solicitor haven't been assessed because they require an integration of some of the elements. So we would be moving away from specifying particular qualifications, whether it's a qualifying law degree or a legal practice course. We would move away from specifying particular qualifications, and we would move away from that tripartite structure.
We've got a couple of other questions, Julia, about some of the details. So someone's just asked for you to confirm, does it have to be a law degree that somebody has, and do you have to have a law degree before you sit the SQE?
So our requirement for degree or equivalent qualification is not a prerequisite for sitting the SQE. It's something that has to be picked up by the time you reach qualification. And if you look at the apprenticeship route to qualification, apprenticeship is a level 7 qualification. It would be equivalent, at least equivalent to a degree, so that would satisfy that requirement. But people would not have completed the apprenticeship until they reach qualification, and that's one of the reasons why this degree equivalent qualifications is not a precursor to the SQE stages 1 and 2, although in some cases it might be. It's a requirement by the time we reach qualification. And no, it's not a law degree, so we are not moving away from the current position where both law graduates and non-law graduates qualify as a solicitor. It's a degree, so it's something which demonstrates that people have graduate level attributes. They've learned that they can manage their time independently. They're independent learners. We recognise that the profession also values non-law graduates and that substantial numbers of non-law graduates qualify as solicitors, and we expect would continue to do so, and we'll explain how that might happen in a moment. So the next slide sets out in more detail what the SQE might look like. We have revised this model and developed it since the first consultation. What we are saying is that this would be a 2-stage assessment rather than a 2-part assessment, and that recognises that the process of leading up to qualification as a solicitor is a developmental one, and that candidates' competencies will be being developed through this process. SQE Stage 1 is not intended to be a knowledge test. It's intended to be a mechanism to assess whether candidates can take their procedural and their substantive knowledge and use that in the context of common transactions and to address common problems that their clients might face. So SQE Stage 1 takes the form of 6 assessments. We call them functioning legal knowledge assessments, and you can see those on your screen. The first one, if you like, is the building blocks of English legal system, public law, and ethics and professional conduct. The next assessments are all Practice-based in the sense that the contexts are common practice areas, so dispute resolution, property law, commercial and corporate law, wills and administration of estates, and criminal law and practice. Those elements have been chosen because they are correspond, as you can see, to the reserved areas of practice. Plus, we have commercial and corporate law because that is such a significant area of practice for the profession in terms of the numbers of people who practice in that area. But what is new about this assessment is that it integrates, as I said a moment ago, both black letter and procedural law. And so if you look at dispute resolution, it will look at the civil procedure rules and other elements, other alternative methods of dispute resolution, but it will expect candidates to be able to take a cause of action in contract or tort, be able to evaluate that cause of action, be able to understand what the key elements are and the extent to which they are made out, and then to adopt an appropriate dispute resolution strategy and a litigation strategy. So they should be able to work out what elements they need to take all the way to trial, what elements they can resolve at an earlier stage, whether there are elements that they should be, issues in the case they should be agreeing or dropping, or whether there are elements that they can resolve by way of summary judgment or preliminary issues. So it brings together their knowledge of the civil procedure rules and dispute resolution mechanisms and their knowledge of contract and tort. And that model goes all the way through those assessments. And it's bringing together, as I say, what at the moment are elements are assessed separately. So you have the black letter law elements that are assessed in the qualifying law degree or the CPE in the academic stage, and procedural elements which are assessed in the LPC stage. Ethics would pervade all of this, so although we would have principles of professional conduct assessed in the standalone assessment, identified at the top of SQE stage 1, we would expect ethical issues and professional conduct issues to crop up as you would expect in these sorts of contexts. So in dispute resolution, it might be your duty to the court. We might have anti-money laundering cropping up in property law and so on. Black letter law would be integrated all the way through that, so commercial and corporate law and practice would include tax, as would property law and practice, also would incorporate contract law again, so all the underpinning elements that you would need to know in terms of the law to practice competently and safely in those areas would be assessed. And all of that material is set out in our assessment specification, which we have published and you can find online with links to it from the consultation document. We also have, as part of the stage 1, a practical legal skills assessment, which would assess the written skills of legal research and writing. The functioning legal knowledge assessments would be computer-based testing, so they would be single best answer or multiple choice questions. We think that we can assess higher cognitive skills, application, synthesis, analysis through those mechanisms. We've talked to other professional regulators who use those mechanisms, both other professional regulators in this country and international legal regulators, and they all confirm that you can do that through that mechanism, through that choice of testing instrument, and that they do indeed do that. But there are some things you can't test. So clearly you can't test a candidate's ability to write discursively or to undertake legal research. And the profession told us at the end of SQE1 consultation that they wanted people arriving in the workplace with minimal skills that they could use in the workplace. And these were particularly the written skills, an ability to undertake legal research, an ability to write clearly, accurately, professionally, and so that we would incorporate into the first stage assessment those written skills tests. SQE stage 2 we would expect would be taken at a later stage, probably after a period of work experience. And the core point about SQE stage 2 is that it is a skills assessment. Although we talk about these skills being assessed in legal context, Those contexts provide the platform for the assessment of the skills. We would not be assessing the context, and we would not be assessing candidates' knowledge of the law or legal issues related to those contexts. So I've set out on the slide the Stage 2 assessments, which are largely self-explanatory. The one which might require a little bit more explanation is case and matter analysis, where what we would be proposing there is that we would give a candidate a file, a client file, and the candidate would have some time to read it and analyse it, and then they would go into a live assessment with an assessor role-playing their principal. And what they have to do is they have to brief their principal on the issues in that file, what the legal issues are, the factual issues are, what the risks are to the client, what the next steps are. We would be able to use that to test negotiation. There would be an offer or about to be made or having been received, and they would be able to discuss and be questioned on their negotiation strategy. What's the alternative to the offer or to a negotiated solution? What are your red lines, and so on and so forth. We have said that we would assess this twice, and that's designed to ensure that we assess that the candidate's skills are transferable, and we have set out there the practice contexts in which we would assess this. We've expanded upon that in the consultation. Some of the questions that we've raised in the consultation are, should we assess this only in one context? Should there be more context? Or alternatively, should we say that everybody has to be assessed in all of these contexts, so that a candidate turns up and they're assessed in all of these areas, either in all contexts or in any context, so they don't know before they turn up whether they're going to have their legal research skills assessed in the context of property or commercial and corporate practice. So we've set out a number of alternatives there, and I would be very interested in your views at this stage. So if anybody wants to post questions or comments around any of that, I'm aware there's a lot of detail that's come out there, so I'd be interested to hear your views back.
We've got quite a few questions, Julie, on this particular slide. So the first one is, are we going to publish a syllabus for the SQE?
Yes, and the answer for that is that we are doing that through something we call an assessment specification. So it's not a syllabus as such, but what it is, it sets out what the outcomes are for each element of the assessment, what it is we would be assessing. And we've tested that through a number of different mechanisms, including a Delphi group, and we asked our Delphi group members who were drawn from a range of about 20 universities, Liz will correct me if I'm wrong there, whether the assessment specification would give them enough to design a curriculum, and they said to us that it would.
Okay, another question on in the Stage 1 assessment, how many multiple choice questions would there be in each of the assessments? So
again, this detail is set out in the assessment specification, so please do take a look. What we are saying is that for most of them, it would be 120 questions to be taken in a 3-hour exam. The exception is wills and the administration of estates, where we felt that the underlying curriculum was likely to be smaller, so we're talking about 80 questions over 2 hours.
Someone's also asked a question about the Stage 1 practical legal skills assessment. Would legal research and writing skills in that assessment be assessed through multiple choice questions as well?
Very good point. Thank you for that question. No, it would not. So they would be a discursive exercise. So legal research would be an online research question that would be set where people had to use a legal database to find out what the answer to the research question was and write it up in a memorandum of advice. So it would be a discursive memorandum of advice for use internally in the firm. The writing skills would be assessed through a series of letters, perhaps to a client or to a third party, and I say letter or email. So again, both of those are discursive, and the person who asked the question, I think I would entirely agree with that those sorts of skills could not be assessed through a multiple choice exercise.
We've had another question about the content of the Stage 1 assessments, in particular the fact that family law isn't included as one of the assessments.
Yes, and again, this goes back to the first work that we did in our Solicitors competence statement. We did a lot of work around what do we think the core areas of law are and what are specialist areas of law. And I suppose our thinking around this is we don't need to assess everything. We don't need to regulate the acquisition of all knowledge. What we need to check is that all people who qualify as a solicitor, if you like, have the intellectual equipment to practice. We have to be mindful of the reserved activities because that is what, by statute, somebody who has the solicitor title can do, but nobody else can do, or but people who don't have full practice rights can't do. So we have to be mindful of the reserved activities. So what we have tried to do is we've tried to focus on core areas of law, and then through SQE Stage 2, key skills. And what we think that gives us is sufficient comfort that somebody has, as I said a moment ago, the intellectual equipment to go off and get themselves up to speed in other areas. So they've got the ability to understand what they need to do to become competent to practice in, whether it's family law, employment law, finance, welfare law, whatever it happens to be. They've got the essential building blocks so they can go off and get themselves competent to practice in those areas. We don't think this means, and we don't intend to suggest that there does not need to be learning and training in those areas. There absolutely does. The point is, for us, whether we need to regulate that training, and we don't think that we do need to.
Another question is about resits, Julie. And is it still the case that there are unlimited resits in terms of how many times a candidate can sit the SQE test?
We never actually proposed that, I think, in our first consultation, but there were a lot of people who thought that that's what we were proposing, so we have clarified that this time. What we are saying is that candidates would have 3 attempts over a period of 6 years to get through SQE Stage 1 and SQE Stage 2. So they'd have a first sit and then 2 resits.
Another question someone's asked is, where will students sit the assessments?
Again, very good question. What we would be proposing if we went ahead with this idea is that we would appoint a single assessment provider, and we would expect them to have a network of places to which candidates would sit these assessments. So for SQE Stage 1, there would be a network of secure centres where they would sit at computer desks and they would undertake these assessments. And we are proposing that SQE Stage 1 could be taken both in England and Wales and internationally, as is the case currently with the Qualified Lawyers Transfer Scheme. SQE Stage 2, as you can see, consists of a mixture of written skills assessments and oral skills assessments. Again, the written skills assessments would be taken in secure examination centres. The oral skills assessments would be taken in assessment centres too, but they would be slightly differently configured because they would need to provide for the oral role play. Those would be, the oral skills assessments would have to be taken in the country.
A couple of other questions. What happens in Stage 2 if a candidate gets the law wrong?
A very good question. I said a moment ago, didn't I, that SQE Stage 2 is all about the assessment of skills, and that is indeed the case. However, if you are undertaking a piece of advocacy, then part of the skill of the advocacy is choosing your most persuasive argument and expressing that clearly and in a persuasive way. Part of that is having an argument which is legally correct. What we would propose is that we would provide candidates with the relevant law, and then part of the assessment would be can they take that law and can they use it to formulate a correct legal argument, or to underpin identify the correct questions to ask in a client interview, or whatever it happens to be. So if you've got the law wrong because you're unable to use the law in those contexts accurately and correctly, then you would not be competent.
Someone's asked whether we've coordinated with the BSB over the development of the topics that are assessed in the Stage 1.
So we have been talking extensively to the BSB throughout this process, so we have indeed talked to them. We actually are operating in slightly different markets. So this is what we require for qualification as a solicitor, and I think the BSB does have different proposals around this, but actually when we look across the two of them, we think the two can be made to work together. So, for example, if you take a law degree that prepares you for SQE Stage 1, then I think that would also prepare you for qualification as a barrister. So the two can be made to work together.
And someone's asked a question about whether there's a charge to sit the SQE, Julie. So is there a charge to
yes. So
sit the SQE? Who would determine what level that fee is set at?
So I said that we would be appointing a single assessment organisation if we proceeded along with these proposals. As part of the contractual relationship with our assessment provider, we would wish to control the fee for these assessments. So there would be a fee to candidates for taking the assessments. A lot of people have asked us questions about the cost of qualification, the cost of the assessments. It's difficult for us. We do not want to give an indication which pitches the which influences the procurement process in a way that it should not. However, what we can say is that we've done a lot of modelling in terms internally about this. The cost of qualification is very, very sensitive to the number of candidates taking the assessment. And so because we think that the number of candidates would be far more significant than those taking the QLTF, we think that there are lots of opportunities, particularly around SQE1, for economies of scale, really dramatic economies of scale. And we don't think that the QLTF particularly provides a benchmark around where the fee for these assessments should come out.
I think that's all the questions on this particular slide. A few people have asked, will you be able to receive a recording of the webinar? And just to say, yes, we are recording the webinar and it will be made available probably by tomorrow for those of you that want to listen to it again. We're just going to move on to the next slide now. I'm
going to try again to click through on my screen, but I'm afraid now it looks as though it's unresponsive. We are moving on next to the preparatory training for the SQE. So this picks up, I think, a question that somebody raised earlier on. Our proposal is that we would not be specifying any particular preparatory training for the SQE. What that means is that we would no longer require candidates who wish to qualify as a solicitor to have taken a QLD, an LPC or a CPE. Again, as I said, it's a question that somebody asked earlier on in this session. We think that that gives greater opportunities for providers to develop different approaches. So it means that instead of particularly the LPC being, if you like, a franchised course where you take the course down off the shelf and that tells you what you've got to do, what you've got to teach, what the order in which you've got to teach it, providers would be much freer to think, well, for my particular group of students, this is the course that would work best for them. Like in an A-level, a school has an exam that they're preparing there, an external exam they're preparing their students for. They know what the exam is that they have to prepare for, but classroom teachers have the ability to work out how they want to prepare their students. They understand their students, they know their learning needs, and they can design a course which is responsive to that. It's a similar sort of system that we would be proposing here. So a lot more freedom, a lot more opportunity for providers to use their educational expertise to devise courses that work for their particular groups of students. As I said at the start, we would propose to publish data on the performance of on the SQE to inform choice. What does that mean? We would release data about candidates' performance on an anonymous basis on the SQE. We'd provide information about the pass mark, the pass rate, the number of candidates, the distribution of candidates' scores, and candidates' prior education and SQE training. So all of that material would be available and open to candidates to help inform their choice. We think this would make for a more competitive marketplace. We think that there are more opportunities then to drive costs down and quality and as I say on the slide, candidates would have greater flexibility to train in ways that they like. We absolutely recognise the need for information for students to make a competitive marketplace work effectively, and in fairness to students, students need to understand the choices available to them. And we would envisage preparing a toolkit of resources for students, which would include case studies, questions to ask of providers, information about what particular pathway to qualification might suit them. And it might also include the information on the next slide about, which we can move on to. So this is the possible new routes to qualification, which we want to move on to. And these are the exemplars. So these are examples. These are not specified routes or limited routes. These are possible new routes to qualification, but these are examples of how people might qualify. I'll take a pause there before I go into describing these routes in more detail, just to pick up questions that are coming through.
One of the questions we've had, Julie, is what's happening to the LPC and what's happening to the PSC?
Yep. So, as I say, we would no longer specify that people had to take the LPC. We wouldn't be outlawing it, saying it's illegal to take the LPC. So if people still did want to take the LPC, if there was sufficient demand for it, then people could take it if they wanted to. But in a more dynamic, competitive marketplace, students could choose either to take something like the LPC or to train in a different way. One of the things that we are no longer proposing to assess is the LPC elective subjects. Obviously, at the moment, although we say people should take elective subjects, there's no requirement for you to have done so in order to practice in those areas. And so we are suggesting that we wouldn't regulate the subjects which at the moment are commonly taught at that stage. So any LPC people, we recognise people might still want to pick up that information, that knowledge, but it would be up to employers and students and education and training providers to think about different ways for students to learn that information. It might be through distance learning during a training contract. It might be through a short focus course before people begin their training contract, or a short focus course integrated into another course of study. There'll be lots of different options for people to pick up that information, and we would not need to specify how it was learned or how it was taught.
And the professional skills course?
Yes, and the professional skills course, again, we would no longer require people to take the professional skills course, as it wouldn't be a requirement. There are some elements in the professional skills course which we have to take care of because they, for example, FISMA in relation to financial conduct authorisation, and we would pick up those elements in the SQE.
And another question, Julie, is so does this mean that you can just turn up for the SQE without any training at all?
So what we expect, and again, it's if you look at through the possible new routes to qualification, we would expect that people would have to take some there is some learning involved here. So in order to qualify as a solicitor, in order to take SQE1, you do have to know a broad range of legal knowledge and legal processes. And so we would expect that people would have to acquire that in particular ways. It might be through distance learning, it might be through taking a degree, it might be through formal accredited training, it might be not through formal accredited training. So there'll be a range of ways in which people could do this. And again, we wouldn't regulate or specify how that training happened or what form it took. We would, however, as I said at the start, say that everybody would have to have a degree or equivalent in order to qualify as a solicitor.
Another couple of questions, Julie. One I think you've touched on already, but it's perhaps worth asking again. Won't this choice of routes be confusing for students, particularly students who might not have legal connections and know which is the preferred route by employers?
I think this is a really important question, and the students do need to understand what the choices are that are available to them. Actually, we hope that there's a lot more transparency around this than there is at the moment. So there's a lot more transparency about which providers have high pass rates on the SQE, and there's a lot more transparency about the purpose of particular types of degree. And perhaps we can pick that up through beginning to look through the exemplar pathways. So if you look at the slide on possible new routes to qualification, a lot of you will recognise that this is not a million miles away from where we are at the moment. We hope and expect that actually these exemplar pathways will develop and perhaps become more unfamiliar compared with where we are at the moment over time. But certainly in the early days, we think that these are the most common pathways that people will be following to qualification. Graduate Example 1 is a 3-year law degree, which might include SQE1 prep. So one option for universities is to integrate preparation for the SQE Stage 1 into their degrees. We then the SQE1, the little purple circle, the assessment itself might be taken shortly after students graduate. I mean, again, when we've talked to universities, we've had a range of views around this. Some universities say they would integrate SQE teaching into their course. Others said they might not integrate it into their degree, but they might offer extra summer courses or courses over the summer after graduation for their students. Others have even said that they are interested in looking at whether SQE1 assessment could be part of their assessed qualifications. So a lot of variety around that, but the principle is that in that case a degree would train people for and prepare people for the first stage of the SQE. Then we expect people would take a period of qualifying legal work experience, and at the end of that they would take SQE2. We expect that if somebody has had a good period of work experience, there would not be the need for extensive additional training at that stage. If you have had experience in your training contract or in your work experience which has given you exposure to clients, where you've done lots of drafting, lots of legal research and so on, that should enable you to take SQE2. You might want to do a mock assessment, a weekend course, but we don't expect you would need a dramatic amount of additional training on top of your work experience. Graduate Example 2 is effectively a sandwich degree, so where you have a 4-year law degree which includes a 1-year work placement which might count towards your qualifying work experience, and then it's pretty much the same. Graduate Example 3 is a traditional 3-year law degree, an academic law degree. We know that some universities are thinking, we are academic lawyers, that's what we know, we are not practicing solicitors, we can teach what we know and what our expertise is, and we would not include preparation for SQE1 as part of our degree. And that's a perfectly legitimate position to be in, and it's perfectly it's good and transparent for students to understand what sort of tuition they can expect from their university. So we expect then that there would be the need for some additional preparatory training to cover the subjects which at the moment are the procedural subjects taught on the LPC, so to cover civil litigation, conveyancing, commercial property and so on, to prepare you to take SQE1. The apprenticeship model would integrate all of those elements into one, and Graduate Example 4 is what at the moment is the GDL route. So this is where somebody takes a non-law degree. They would have to do, we would expect a longer period of preparation where they learn the academic law and the procedural law in order to be in a position to take SQE1. On this time scale, I think I should probably just clarify that we expect, although we said at the start the time scale might be 4.5 years, actually I think we should clarify we expect that pretty much you wouldn't be able to qualify under any of these routes in less than 5 years, although that does depend on how long qualifying legal work experience is. If we specify it at 18 months, it might be 4.5 to 5 years. If it's 2 years, it would be no shorter than 5 years. So pausing there, the next slide is work experience. Let's just pause there to see if there are any questions on that.
We've got a question about what work we might be doing with school careers advisors if we should go ahead with the SQE and change the route to qualification.
So we hope that everybody has a part to play in that. We hope that universities would have a part to play in that in terms of outreach and in terms of explaining what their offer is in terms of their law degree, what it's designed to do, how people qualify. So we would be putting out information in terms of this toolkit of resources. We would want to work with AGCAS and the Association of Graduate Careers Advisory Service, and we would hope that universities and in terms of their outreach would want to work with schools and that the Law Society and everybody, firms, I think all stakeholders actually have a part to play in communicating this to intending solicitors and students while they're still at school.
A couple of questions more about the SQE1 assessment. One is, are we requiring candidates to sit all the SQE1 assessments in the same assessment session?
Yes. We are. And it's quite helpful to describe what we mean by assessment session. We're not expecting everybody to do this in a day, but we are expecting that we would have an assessment window, like you have a period of time over which A-levels are sit in a particular year. So this assessment window might be 4 weeks or a number of weeks over which candidates would have to take all of these elements of SQE1 at one go.
And a related question is, how many opportunities will there be during a year for someone to sit SQE1 or 2?
What we have said in the consultation is that certainly at the start we would expect there to be at least 2 assessment opportunities, and we would like to work with stakeholders, work with universities and law firms recruiting trainee solicitors to be clear what the best timing is for that. But having 2 assessment windows a year gives people an opportunity to come through different routes and also to resit and not have to wait a whole year before they have to take it again.
We've got quite a lot of questions on work experience, which we'll move on to next. So we will pick up those questions in a moment. But we've just got one more about the length of training. And someone's just asked to clarify whether the figure at the end, where it says time scale at a number of years, is that in addition to the length of a degree, or is that the total time including the degree?
No, we expect that that's the total time including a degree, but as I said, those first 2 points, 4.5 years, that really depends on the length of time of the qualifying work experience. So I could see that you could do that in 4.5 years if the qualifying work experience is 18 months. If actually it's 2 years, and this is something we'll go on to explain in a moment, it would clearly have to be, no, you couldn't qualify in less than 5 years. So let's move on then to the next slide, the work experience, and take a moment for that to come up on people's screens. Yep, so I hope you can see the work experience slide. So this comes, the first point here is the point we've just been talking about. What we are proposing in the consultation document is that this should be a substantial period. We had a lot of feedback and very, very strong views that this was one of the hallmarks of the qualification as an English and Welsh solicitor, that a substantial period of workplace experience was needed to develop the competencies, and that this was a very valuable way of learning to be a solicitor. And we agree with all of that, and that's why we have said in the consultation we think this will probably remain 24 months, but certainly we don't think it should be less than 18 months, and we'd be interested in your views around that. What we say is that this experience should take place either in a regulated entity or under the supervision of a solicitor. Importantly, what we're proposing is what the entity or the solicitor should do is not sign off that candidates have demonstrated the competences in the competence statement, but rather that they've had the opportunity to develop those competencies. And then it would be through SQE2 that we would assess whether the competencies have been developed. So that's where we'd assess whether somebody has the competencies, but what we would expect of employers is that they provide an opportunity for individuals to develop those competencies. So that's what we are proposing in relation to the work experience. And moving on to the next slide, just take a moment to click through to that. That's gone through. We are suggesting that we would no longer require that work experience should give people experience to 3 areas of practice and both contentious and non-contentious practice. What we think that work experience needs to focus on instead is developing the competencies. So those competencies set out in the competence statement, that's what the purpose of the work experience is, to give people an opportunity to develop those competencies. Those competencies on our current proposals would be assessed in 2 different practice areas, and we have said that the assessment need not be in both contentious and non-contentious. We recognise that this means a change to where we are at the moment, but actually our informal engagement following SQE, the first consultation and leading up to the second consultation, was that many practitioners that we spoke to recognise that actually what happens is that once people have decided to become either a contentious or a non-contentious solicitor, it's very, very rare for them to change. So assessing their competencies and allowing them the opportunity to develop their competencies either in a wholly contentious or wholly non-contentious work experience means that they can develop and get very profound competencies in those particular practice areas. So it gives a bit more flexibility. And the final point to say is that this also means that what we're proposing is greater flexibility in terms of what counts by way of qualifying work experience. So any experience which helps, which provides an opportunity for somebody to develop their competence would count. This means time spent as a paralegal, in a placement in a law firm, part of a degree, in a student law clinic, in a training contract. All of that experience could contribute to our requirement, and through a range of different employers. We've asked a question in the consultation about whether we need to put any limitations around that. Should we say that no more than 4 different employers or experiences, or should we say that the minimum time that we would recognise would be 3 months, and we'd be interested in views around that. So any comments or queries on work experience?
Quite a few questions on this, Julie. One of the questions was, currently in a period of recognised training, candidates are signed off by a training supervisor. Would there be the same requirement with the SQE?
So there would have to be somebody who signed them off. It need not necessarily be somebody who has day-to-day supervision, but there would have to be somebody who was a solicitor or an authorised person within a regulated entity who took responsibility for signing off, for confirming to us that the candidate had had the opportunity to develop their competencies.
Another question is, what evidence would a candidate or an employer need to collect that the student had had the opportunity to develop their skills? Would it be a portfolio, for example?
Yes, we are proposing that the candidates would have to keep a learning log. So they would have to keep a record of the activities and the ways that they had developed their competencies, what they had done, how they had developed their competencies, what experience they had had, so that we could, if we came knocking on the door, that would be available for us to have a look at.
A slightly different question is, are we considering practice-specific certificates?
I think, is that a question about whether we're saying somebody has a practicing certificate only to practice as
contentious.
So no, we're not. It's a question which we do get asked quite regularly. It's quite interesting that it's cropped up again. We have given some thought to it. We're not proposing it at this stage, and one of the reasons for that is that we do worry about the issues in relation to consumer protection. If somebody has the title solicitor but a reservation on their practicing certificate, what signals that sends out to consumers about what work that solicitor is allowed to do and not allowed to do.
Another question, which I think you've probably covered, Julie, but perhaps worth repeating. Does our approach to work experience mean that employers are still deciding who is competent? And if so, doesn't that just repeat the problem we have now of 2,000 to 5,000 employers making a judgment about competence?
Yeah, it's a very good question, and it is a question that we thought very long and hard about. We are concerned about the current position where we've got 5,000, in fact I think more than 5,000 authorised training providers, and at any one go between 2,000 and 3,000 people who take trainees on. We think it's just impossible to make sure that everybody is assessing and signing people off to the same standard when there are such large numbers involved. And so we're not asking employers to confirm to us that candidates are competent. We're asking them to confirm that candidates have the opportunity to develop their competencies, and we then would assess competence through SQE2.
Okay, I think that's all the questions so far, Julie.
Fine. Okay, so let's move to the last slide in our concluding few minutes. Next steps. So next steps are that we've launched this consultation. It closes on the 9th of January. Please do put in a response to our consultation. The worst of all worlds is that we put a lot of effort and time and care into publishing a consultation and we get no responses. So we're very, very keen to pick up your views and hear from you. And please put in a response. So closes on the 9th of January. We then would hope to get a decision from the SRA board about whether or not to move forward with our proposals spring, summer 2017. We have already said that the SQE would not come in before September 2019. In terms of transition arrangements, what we're proposing is that anybody who has started a QLD before September 2019 can choose to continue to qualify under the old system or to qualify under the new system. No pick and mix, but people can choose, so those people would have more options than they do at the moment. But anybody who starts after that, somebody who's not started a qualifying law degree or later stages of training before September 2019, those individuals would have to train under the new route to qualification. So those are the next steps. That's the timetable. I think we are just about out of time. I don't think we've had any more questions coming through. As Liz says, this will be recorded. Please do contact us if there are any other questions occur to you after this. We'd be very interested and happy to deal with questions as they come through. Thank you very much indeed for your attention, and we look forward to hearing from you with any comments or queries you may have. Thank you very much.